Okay, so by today, you should have your 103 questions in, and the answers to all of your questions that have been posted online. And for Thursday, there will be no class here. I've got to be in Boston with the trial teams. And you have an assignment that is posted online, and I'll pass it around, and it is to draft a complaint, and I've given you some instructions on how to draft a complaint in federal court from the federal district court here. I've given you a copy of a complaint, but that's they use lined paper there, as you'll see, and we don't use that around here. So you've got some information and forms, but don't go solely by the forms. You need to take those facts and adapt it to a complaint that would be acceptable for filing in court. And obviously, in this complaint, there's a concern about injunctive relief as well. So you need to think it through exactly what you want for relief, what it is you're asking the court to do, and then prepare it as if you might be a real lawyer someday soon and get someone to pay you for this. So give it a little bit of thought, but it shouldn't, it's not an overly complicated fact pattern, but it does ask you to apply some civil procedure to what you should know a little bit about, which is drafting documents, complaints, specifically pleadings, and the first document that you file in court in a civil case is in fact the complaint. So that is in substitute of Thursday's class. That should be submitted by the next time we meet, which is the following Tuesday then. And it's pretty straightforward. It's the New Hampshire Chief example from the spring of 2014, and that's posted online already as well. Thank you. We're on, I just want to talk briefly about a couple of the cases in Section 7. We are actually on Section 8. But in the year of snowstorms, the last time we were supposed to meet, we had yet another snowstorm. And the two cases that we didn't get to were Branley and Kaplan. And I just want to talk about them quickly because the Branley one raises another important issue with respect to insurance practices. And that case is an interesting case, I think, because it is one of the few cases you're going to find where it wasn't the insured who is actually arguing that they can recover under 176D because of the wrongful refusal to effectuate a prompt settlement. What that case says, and it's one of the few you're going to find that actually say it, is that even the adversary who hasn't been made a prompt settlement offer, who didn't procure the policy, who doesn't have contractual privity with the insurance carrier, can still, down the road, argue that the insurance company for the adversary failed to treat them properly. As a general matter, that claim belongs to the insured because of contractual privity. And oftentimes what will happen with that type of claim is after the fact, if we have what we call an excess judgment, a judgment beyond the limits of the insurance policy. And what that means is if you sue someone and they're insured for, say, $50,000, $100,000 in an automobile policy, what that means is $50,000 per person injured, $100,000 maximum regardless of whoever's injured. Okay, 50, 100 policy. Sometimes some policies are 100, 300, some are 20, 40. It's a question of what the policy limits are. But when we sue someone, the fact is that if there's no insurance, then we've got to figure out how we're going to satisfy that judgment. Some people have personal assets, some people do not, and so the policy limits become important in trying to assess the true value of the case, because the value isn't $5 million, even if those are your client's damages and you can prove that, if the person doesn't have $5 million or anything close to it and never will. So what we look for are, what are the policy limits covered? I'll give you a quick example. I was sued down on Rhode Island for the acts of one of my offspring in driving one of my cars. and I had a $300,000 policy on that vehicle. Person driving was, who caused the accident, just over clip, was 93 years old. And ultimately, I mean, if you're in your 90s, you're going to pass away, but she didn't pass away as a result of this, but she did pass away at some point. I have a significantly large policy. The liability is low. I'm telling the insurance company to settle. I don't want the case tried. I don't want to risk what we call an excess judgment, because it is, at the end of the day, one could argue that it's a death case. Even if you're 93, you've got losses. And so who knows what a jury would do. If you try cases, you never know. Verdict could come in at, say, $500,000. That would mean at the minimum there may not be coverage for $200,000. There may not be coverage for $400,000, which means they're going to come after me. So I push my insurance carrier to settle. Listen, I understand it's a no liability case. She ran the light. Give her the $300. Doesn't cost me a dime, right? And that's the argument. So even though you're insured, even though your client may come in and say, no, the insurance company lawyer will defend the suit, the fact is, to some extent, you're in conflict with the insurance carrier, even your own insurance carrier, because they think they can try it to a zero verdict, which ultimately they did. But the fact is that's great. But before we got there, I had an agreement that if they try it, as opposed to making what I thought would be a reasonable settlement offer $150. I don't care. She had 70 grand in meds. Offer her 300 grand for all I care, because it doesn't cost me a dime. But if you're going to try it and you think you're going to win, then under 176D, you have an obligation to me to offer the settlement. And if you're not going to, if you're going to roll your own money and roll mine, then you're going to guarantee that I won't be obligated for an excess judgment. That's what a private lawyer will do between you and your insurance carrier. And that's what 176D requires them to. Because if there's an excess judgment along these lines, what oftentimes will happen, it's not the opposing party who generally has the right to the claim, it's the person in contractual privity with them, the person that procured the insurance policy. And so then if there's a significant excess judgment, what will oftentimes happen is the plaintiff may ask, in return for allowing you some relief from that excess judgment, ask for an assignment of that claim against the insurance company. So in essence, I will release you from any further liability, but I want to be able to sue your insurance company under 176D for the failure on your part to make a reasonable offer of settlement prior to trial. And so that's more often the way this works. In this case, the way it worked is that the plaintiff instituted their own wrongful refusal to settle claim. And I thought the history is interesting in this case simply because the plaintiff's lawyer is arguing, well, I don't have any obligation to be reasonable at any point, because his first request was 7 figures or thereabouts, is my recollection, and he ultimately settles for somewhere short of 6 figures, 10 cents on the dollar in essence. But his argument, and I know him, early on, I tried many cases against him. I could see him saying that with a straight face, is that I don't have any obligation to be reasonable no matter what. It's the insurance carrier's obligation, and even if I make a silly demand, they have to respond reasonably under the statute, under 176D. And in fact, that is correct, is that this regulates, like 93A regulates business-to-business activity, this regulates the activities of the insurance carrier. And it is important that when you have litigants who are insured, that you still likely are going to need to take an active role, because it's not in the insurance company's interest, as a matter of course, to settle for the entire policy. If they're saving money, they may be more apt to, but if you've got a $1 million policy, they don't want to part with it. And the risk is that if there really is a $2 million case, a $1 million payout means you're still home free. A $2 million judgment means they'll pay the first $1 million, you pay the second. And that's likely going to bankrupt most people. Do you understand those principles? So 176D is, we use it here, in this case, to make sure the insurance company stays reasonable. And then I thought it was interesting here, after the fact, my guess is the insurance company paid a premium to vacate this judgment and the finding, because it was one of the few cases you're going to find that the non-insured brings the 176D claim. And then lastly, we've got this Kaplan versus Feldheimer, which is another odd situation with respect to insurance, where the plaintiff doesn't want them to settle. And the plaintiff doesn't want them to settle because he wants some type of retraction of the claims before they settle, and then, in essence, his reputation is injured. And it raises an interesting issue that I want to address, I want you to think about, is that what provisions would you recommend your client to make? And by provisions, I mean apologies, destruction of the evidence, when the financial terms are such that they're satisfactory, but what they want, like here, he wants the plaintiff, even though they were paying, my recollection is in excess of a couple $100,000, and they don't pay that type of money unless there's ample evidence to support it, he wants the plaintiff to say, no, none of the claims are true. Would you tell your client to do that and take the money, if that's all that's separating you? Make it 300, so it's a nice, easily divisible by 3 for you. 300 grand. All she's got to say is that the claims weren't justified, weren't true. Put a cool 100 in your pocket. Well, what would you say?
Wouldn't it depend on the circumstances? I mean, if now they make that retraction, what about their reputation?
Well, how about? Well, and that's the worry. That is the worry. Plus, it's not true. It may not be true. Claims are true. You're telling me I have to say they aren't true simply to get 200 grand. And when we say, by the way, simply to get 200 grand, you need to think of 200 grand in a big pile on your table. And you know how long it would take to get 200 grand in a big pile on your table. So it's not as easy as saying simply to get 200 grand. 200 grand cash. So, not a big deal? Or it is a big deal? Or we just have to, or we're lawyers, we'll have to work out the words. Is that what it is? I won't say the claims are groundless, or that the facts as I stated them weren't true. Can you live with the evidence may not have supported judgment for the plaintiff? I mean, is that all we're going to do? We're going to be Weasley lawyers? I mean, not Weasley lawyers, but we should be able to use our words to come to some form of agreement that everyone can live with. Or no, I want an apology for bringing these groundless claims. Client says, I can't do that. That's good? Or are you going to try and sell it? You can tell me anything? I say, no, it's your call.
You gotta, I mean,
100 grand.
If they need the money right up front, you say you're gonna get it immediately, or they're gonna keep this going. It could be years before you see a dime.
Could be. Oh, and you may see nothing, right? We try cases. Best case sometimes doesn't come in the way you expect. You try the same case to 2 different juries. Going to have different results. Not potentially. You'll have different results. The question is, how different will they be? It's just the way it is. Would you tell your client to say something that's not true in order to grab the money? Charlie?
Give them the option.
Give them the option.
It depends. It really depends on the situation.
Well, let me ask you that, by the way. We talked about that first year in Cipro. Whose option is it? It's theirs at the end of the day, right? They decide whether to accept or reject. But you're gonna sign off on this deal, even though all along they've told you this case was 110% true. And now all you got to do is say, no, the claims were baseless. See, it says right there, baseless. By the way, I'd have a little trouble as a lawyer signing off on that, because then I'm wondering if they're coming after me, but I guess I'll throw my name in the release as well, and so no matter what happens at the end here, we'll all have a bulletproof agreement that no one's suing anyone, and including me, if you're going to say baseless. Again, right, you ought to think about that, because Rule 11 comes into raise its head depending on what you say. But would you be part of that deal, or are you going to say, no, I can't be part of that deal, that's a lie? As I know it, that's a lie.
It's true. What if something else happens down the line to the same person? Now you're going to see they signed a retract saying, we just took money, but we had no claim. And how are you going to win your next case?
Well, we can put, and we would put other provisions in here. See, he wants the retraction. Sometimes the agreement's going to be confidential, and there's going to be no disclosure of any terms absent a subpoena for those documents. And if there's even a subpoena, I want the opportunity to oppose the release of that, so I've got to be notified of the subpoena. So there will be confidential provisions within it as well. So I mean, you could sort of sleep yourself a little tighter if you want by saying, well, no one is supposed to talk about this ever. By the way, no, you didn't. Someone, was it you who gave me this case? Someone showed me the case. Florida. College administrator, I think, is fired, sues for age discrimination, among other things. University settles with him somewhere around 7 figures.
That was I didn't, but I think I knew where their daughter posted online and they
Confidentiality provisions within the agreement. It only allowed him to disclose the provisions between he and his wife. Okay? His daughter was a student at the same university. I mean, generally they go for free. She posted, going to spring break on whatever the name of the university is. Thanks for screwing my dad.
Yeah.
Words to that effect.
Thanks, Daddy.
University sues, says, give us the money back. You forfeited the provisions under the confidentiality agreement. You owe us whatever we paid you. They won. Because of the daughter's disclosure on Facebook, they had to give all the money back.
Isn't it their fault for telling their daughter? It was only supposed to be between him and his wife.
That's the way the Court of Appeals said.
Teenager, we just won $100,000 off the college that just fired me, and what do you think's going to happen? You deserve to lose it.
That's the way the Court of Appeals said, is that the father said, well, she was sort of in the middle of all this. Her friends are saying one thing, and they know this, whatever the dirty laundry that was there all out, and he thought he had an obligation to tell her that Daddy was exonerated. Well, if that's, then she should have been in the confidentiality agreement if that's what you were going to do. Because when you told her you violated, that the Court of Appeals said, it said you and your wife can know. Telling her violated the confidentiality, and that money comes back. So all of these agreements, this is the point I'm trying to make. All of these a lot of settlement agreements, once the case is beyond sort of typical case, they all have confidentiality and forfeiture provisions. They all may ask for return of documents. It's rare, generally, that beyond confidentiality, the return of evidence, and non-disclosure, that you have, and I want an apology. But it does come up. And it also comes up in the context of sort of the non-disclosure. So I'm not supposed to disclose to all these other people who might be victimized under these circumstances, or the Ford Explorer cases where those tires were exploding on people. They paid a premium to settle the early cases. And so you and your client, part of the cover-up then, right?
And McDonald's coffee was a non-disclosure too.
Yep, they're all, major companies are going to want non-disclosures of the terms, because someone hears you get $700,000 for dumping a hot cup of coffee in your lap. They're not going to be the last person that sues. And so they want to make sure that information isn't out there.
With these complaints that are filed, will the State Discrimination Commission use just whatever media coverage or the filing of the complaint to launch an investigation? And then what is the confidentiality agreement even mean at that point?
Well, if the complaint is filed, when we settle the case, there's probably an answer on file, a complaint, and then all that's on file then is a voluntary dismissal signed by the lawyers, sometimes signed by the clients, usually not. The lawyer's appearance is enough. Between the clients, there are general releases. The only public document you'd have would be the complaint, the answer, which denies everything, and then the dismissal. So if they're going to investigate at all, they would have done so before. If the case has been settled like this, the general agreement, the agreement will usually have a provision that even if they ask, you can't turn over the information on the settlement. Only under the circumstances of a subpoena, a court order, can you turn it over. And so And so they still don't get to know necessarily what the terms of the settlement are. And the terms of the settlement sometimes won't necessarily indicate how strong the case is. It could indicate how strong the exposure was, and perhaps the concern about some of this information being in the public, some of the claims being public. So does it prevent them from launching their own investigation? No, but it may make it more difficult for them to get access to the evidence, because oftentimes, more recently, people want the return of all the information you've got, and I will give them the information back. I'm not going to destroy information. Sometimes they will ask, well, okay, whatever you've got to destroy. I won't do that. I'm not going to be responsible down the road. If I'll give it back to you, and then if whatever you do with it, you're welcome to. I have a good understanding what's going to happen, but I'm not going to be the one that destroys what I think someone else may want down the road for whatever reason.
What about the courthouse?
The courthouse
They
is.
hide that stuff, or?
There's not, no, they don't have all the discovery, they don't have the information, they would have the summary judgment motions. And these days, in a more complicated case, there's going to be a lot laid on the public record with respect to the summary judgment motion and the factual background for it. I mean, a lot. And so that would be a treasure trove of information that they would be able to use. But some of these cases are going to be settled before then, and so you've got a complaint, you've got an answer, and now you have a voluntary dismissal. And that doesn't necessarily tell you what the claims are. And you know, it would be nice if, Matt's point, that some of these agencies would be more aggressive, but I've had good cases where you would think there'd be more interest in investigating what appears to be more widespread abuse at companies and the like. And unless it's ridiculously sensational, there's not a lot of interest, and there's not a lot of interest till the case actually gets a judgment, because until then it's still claims and the like. If it gets a trial, then they may cover that. But short of that, it's hard to gather interest unless there's really sensational claims. You know, the ones, you know, salacious and the like, that people say, oh my God, you wouldn't believe what that person did. But so here, I just want you to think about it, because it's taking a little longer than I thought. To what extent do you, in essence, tell your client to lie because they're going to get everything else they want? And I don't know whether, well, I will say, I don't think you tell them to lie, but at the end of the day, it's their choice. Your choice then is, you signing off on this? No, you're going to, because if you're not signing off on it, you don't get to keep the $100,000 yourself then, right? It's a $300,000 deal. You've got principles. The principles also means I can't take part in this, right? And that's what your principles mean. So you're not taking your $100,000?
I guess you have to weigh you have to weigh the.
Well, you're not lying, are you? The client is, and that's their choice, right? We learned that at Overthrow. The client wants to settle, that's their choice. It is.
Okay, I'll take the money. I got kids to feed.
So you're going to take the money.
I don't know.
How does Rule 11 work there then, if you're signing off on a non-meritorious case?
You know that your client is lying. You know, which means the BPO's coming after you, they know about it for sure. And then if the other attorney knows...
Well, wait a minute, but you're not, okay, first of all, though, you're not lying in a court document, okay? The voluntary dismissal is no, it's not Rule 11. I'm telling you what the law is here, okay? What you're doing, the voluntary dismissal is simply the only document filed with court. It's the other papers that should remain relatively confidential in the hypothetical. Not here. He wanted a public apology that the claims and a retraction of her claims. I think for many people that would be much harder. But let's make it a different number, okay? Let's make it $1 million. I'll pay you 10 times what the case is worth. Okay, listen, we're sitting here in a classroom, okay? Let me tell you the real world. Do you think most people are going to turn away from $1 million?
No, absolutely not.
Let's be realistic.
$100,000.
Huh?
Not if it's worth $100,000.
Not if it's worth $100,000. Not if it's worth $200,000. Not if it's worth $300,000.
No, she's not lying. I mean, maybe she changed her mind. Maybe she thinks they're meritless now.
Well, the meritless when you're going to give me that type of cash, right? I mean,
Meritless now.
And the only problem is they're asking your client to sell her soul and you to assist with it, because your take on that is $333 cash, right?
That's a tidy sum.
But But so, really, I mean, that's really what it becomes in the real world, so it's cash, it's money. Come on, Mike. We're not in church, we're lawyers, and you gotta work with the language though, right? You gotta at least try and see if you can soften it. Because I had one like it. He wanted an apology that the claims were groundless. My guy wouldn't do it, and I wouldn't recommend he do it. So you got to work with Weasley lawyer language, as I said. What can we live with? Because there's got to be language that you can live with. He won't say that. Say that the claims may not have been supported at trial. Even that's a little weak. But there's got to, right? I mean, being reasonable, there must be language we can work with that we can all say, okay, that really says nothing. But we get the cash, right? No, right? I mean, the idea is to make a deal here, right?
And if the client needs money and it's not personal, they don't care about the apology, like, I need to pay bills and I got medical, whatever this damage was.
Well, but right, at the end of the day, that's what you got to think about, right? At the end of the day, okay, we can have our principals. That's a lot of money. That pays a lot of bills. That does a lot of stuff. And I want you to think about it. That's all. Because at times, I can easily tell you, oh no, we can, we're members of the clergy. We're not, right? We answer to the client. Client lives in the real world, as we do, by the way. 333, you could sit here now and tell me no, I'm going to really have a come to Jesus meeting. We're going to say, this is wrong. This is going to be one of the softest, this is wrong speeches you ever gave in your life, because...
Make a donation to the church out there.
Yeah, why are you looking at me?
I'm looking at... I'm just...
I'd probably take it.
No, listen, I think we all are likely to take it. I think, well, the risk is, I think you got to be careful trying to sell it, because at the end of the day, it's the client's call. And I think at the end of the day, to some extent, you want to at least try and leave the client with a little more dignity than just, I'm taking the cash and running. So maybe there are ways to work with the language. It's, I guess, in part, I'm saying two things. Just because someone says it's got to be X, if we're moving towards a resolution, it can be less than X. That's just the way life is, and so you got to get creative and try to think about how to meet that. There will be times where it's going to be close to X or it's not going to be there at all. And the problem is, as a practical matter, if depending on what the money is, there's a lot of deals you can just take it or leave it. There's going to be deals where they can't take it or leave it, and so then we've got at least an ethical dilemma that's a little different than when we sit here and say in the classroom, oh no, I'd never be part of that.
I didn't catch what you said about the Rule 11 obligation because it's not a court document. They can't. You're saying it's not
Okay, let me explain that. The only thing filed in court is a voluntary dismissal. So there's nothing wrong with filing that. It just says we're agreeing to dismiss our claims. The problem with rules, so it's not the confidentiality and the general release do not get filed in court. That's the reason is they don't want them filed in court is so that no one can see them. So it's not a court document. So you're not lying in that court document. The problem with saying the claims are baseless, or this retraction here, is it does raise Rule 11 issues with the initial filing. And so that's why you would want to make sure that in that release, in the global settlement agreement, that it specifically says that there can be no further claims for Rule 11. What it usually will say in a whole bunch of boilerplate language is that this resolves whatever claims, wherever, howsoever arising from the beginning of the world to this date, including, and if they wanted a retraction along those lines, I would include any claims for Rule 11 against the client, their agents, servants, or attorneys, because that's me too, that the agreement would have to be so bulletproof because by signing something along those lines, and again, I think there's a tendency for you to think, okay, so this will resolve, as new lawyers, well, this will resolve it and everyone will go their ways. I'd like to think that, but I'm going to make sure that the paperwork says exactly that, because there will be some people vindictive that they will look for ways then to punish you. And the fact is that it's not illegitimate to say, you as the advocate signed a claim that your client ultimately says is baseless, groundless, not supported by any evidence. it does raise Rule 11 issues. I think it also raises issues about someone could complain to the bar that you brought this claim and said these things, then your client said these things about it, that it could raise disciplinary issues. So you want to be clear. I mean, if, you know, if you're going to lie, then you better make sure you don't get screwed by your own lie, that these claims were not supported at all, because that raises Rule 11 issues back to the original complaint. And that's what I'm saying. And that's, I don't know where he was going. He's a lawyer. I think he was more concerned about reputation, but I don't know what his end game might have been, and that would have been a concern to me as her lawyer. And also, I think, as Jim points out, is so her reputation. So I have to say that those claims, there was no basis to do it. I'm just a gold digger and fabricating a claim against him. I think a lot of clients would have a problem with that. The question is, what financial hardship are they in that they may not be able to, problem or not, I've been out of work a year, I'm going to lose the house if I don't get some cash soon. And they may not have a choice but to do it. And the insurance company must have thought the claim was sufficiently meritorious. That's not a little bit of money that they're looking at there. Questions on that? Okay, let's get to this. Let's look at this section's questions, which are agreements to arbitrate, mediate, forum selection issues, clauses, and the like. Which, as I've said before, when we've started to look at these types of situations, they're heavily in favor now, both from the standpoint of the forum selection clauses, choice of law clauses, and agreements to arbitrate and mediate, arbitrate, and to actually remove the court from the adjudication process. I think in part because it makes the courts work less, but I think also in part, significant part, is because of the manner of commerce these days. Choice of law clauses and choice of forum clauses save a lot of work with respect to where those contracts are entered into, where the claims could potentially be made. And then the agreement to arbitrate, as long as you're aware of it and you have entered into that with some knowledge of it, the fact is that can be argued that it would speed the resolution process. I don't think there's much doubt about that. But at the same point, there is a significant disadvantage to foregoing some of your constitutional rights, such as the right to the jury trial and the right to institute suit, likely significantly closer to your home forum than what might be a distant forum. Carnival Cruise Lines was one of the first in this sequence, and historically, when we thought about choice of law, choice of forum, and agreements to arbitrate and the like, one issue of concern was the unequal bargaining power that may have been involved between the parties. But as you can see in this case, if you think about it, they really couldn't have much more unequal bargaining power, in my opinion. You've got one of the largest, most profitable cruise lines in the world against, with a couple from Washington State who now have to travel across country to pursue a claim that likely would have been filed in their home state, would have been adjudicated in their home state, maybe even in their own small claims court. But now they've got their expense on this has been significantly increased if the only place they can bring that suit is in Carnival Cruise Line's home forum of Florida. But at the end of the day, as you can see what the court does with it, they say they knew about that clause prior to getting on the ship. With knowledge of the clause, they got on the ship, and they're now bound by it, regardless of the disparity in bargaining power, regardless of whether it's boilerplate or not. And the fact is that they are bound by that unless they could show fraud or overreaching. And fraud or overreaching is a ridiculously high standard in order to try and satisfy. I think this is a good case because I don't think we could have much harsher result if you think about geography from Washington State to Florida and having to initiate this suit. And I don't think it's in here, but I know I gave it to you guys, some of you guys in Cipro. Oh, so, yeah, it is here. Portions of it are here. The clauses that are within the ticket are, I think, some of the other clauses are even worse than this one in how harsh they are, because there's limitations of liability there, both for personal injury and for their personal property. And so when the court talks about there's no overreaching, I think we'll confine that to, they don't see there's overreaching with respect to the forum selection, but there is, in my opinion, overreaching virtually on everything else here. Or not everything else, but significantly others. What does this mean for your agreements with Yahoo and PayPal and all the rest of it, that you're simply clicking I accept without reading any of those agreements? Because I don't think it's any different than the back of one of these tickets that you have, that most of us, when you actually got that ticket, never read. And now you don't. We traveled this week to Wisconsin. That's the first time I've had a paper ticket in seems like 3 or 4 years. Usually now I'm printing off a boarding pass online, having clicked through all the other terms. Are you equally bound to those provisions when you say, I accept, even though you don't even read them?
Should have read it.
Should have read them.
Yep.
Do you read them?
Sometimes.
Sometimes?
I do now.
You do now? Well, let me ask you, when they say, I hear you do now, what difference does it make, though? So I read them. Do you rent a car?
Yeah.
Initial here, sign on the ad, initial here. If I don't, I'm not getting a car, right? So,
And then look at you sideways if you actually take the time to read them.
so read them or not, or read them if they're that bad, then I won't get the car here, but the guy next door has likely the same provisions. Take it or leave it. And whether you read it or not, if you saw it and got receipt of it, that's shame on you, right? Go ahead.
Well, yeah, that's what I wanted to ask you. Do you think that it's possible that this carnival case could ever be overturned? Because I agree with you, it is very cruel. I think it's super draconian. And I think that that's exactly the point, that everybody has the same thing. Well, what if we as a collective society don't want that anymore? What if we don't want to have to go to Miami to litigate, when Carnival obviously has necessary contacts, ties, and relations across the board in the States? So, I don't know.
The statute can say that you can't have an arbitration opt-out, so that would just be a political issue.
Statute can fix it. State law will fix some of it. We have a couple cases in Mass, one against Yahoo, and the other one is against the Steamship Authority. Actually, it's closer to this. And the language is somewhat muddled, but the Yahoo one says, well, if you're aware, but the Mass one says they had insufficient time to actually be aware of the terms. I mean, they saw them, but insufficient time to understand it, and the court didn't bind them to it. But we're kind of the exception in that regard. The fact is the trend is going the other way, is that we'd rather have a lot of these issues resolved. And part of the reason is because choice of law and choice of forum problems, that can take an incredible amount of expense, legal expense, to try and resolve. And so to a large extent it eases the court's burden, so the courts tend to favor it. Federal courts especially favor it. You're going to find some states having more problems with the manner in which it is enforced, and likely giving you some greater latitude under the state statutes. Here the problem is it was filed in federal court. The federal courts tend to favor it to a significant extent.
I was just going to say something with what Steve was saying. I mean, I think just the law moves slow. I mean, when that happens to somebody that's really, really important, or it happens to enough people that, that it seems unconscionable eventually, but I mean, in the interim, I mean, yeah, you have no choice. I mean, until somebody says, hey, that's, not fair, you're going to sign them, because that's why I don't even bother reading them, because what are you going to do? You know what I mean? Like, what are you really going to do? I mean, you could live as a hermit, you know what I mean? But if you don't want to go, you wanna shop online and do anything else, you have no choice, really.
But do you really think it's likely to go the route you're favoring or the other way? Since I would bet if we looked at e-commerce transactions year to year, that it's not getting less. And the fact is that if you're a merchant, like, well, if you're PayPal or you're Amazon, the fact is, just like Carnival, we could be sued in every small claims court in the United States. That's not good. That's going to bankrupt us at some point.
If you want to do business.
Well, but if you,
And I'm not talking about putting something in the stream of commerce, so don't even.
I hear you, but if you want to do business with us, these are the terms of our agreement. Right? You can go, if you can find a real bookstore anymore, you could go buy a book there, if you're even going to buy a book, right? I mean, we don't walk downtown and go into the little shops. If we want something, we want it fast, we click and the little drone will deliver to you in an hour or so now. So,
Not yet.
no, but, right, I mean, you have choices. I would like to think that the consumer is going to get what you would see. The trend doesn't support that at all. The trend supports the favorable business climate.
Well, I think in our days when we go into any airlines, cruise ships, or anything, you are aware that there is an arbitration clause, that you have to go somewhere to get the matter litigated no matter what. So I think that it's on us to be aware of that.
But we know. Do you think people, all these people who are actually, when I asked the question first year, have any of you ever seen the PayPal agreement? And many of you have used PayPal, I imagine, or the eBay agreement. Have you actually seen it? Do you know how thick it is?
It's really.
You don't get caught at all, and you don't certainly get anything around here. It's West Coast. So for this $50 piece of chicken, Jackie, I got to go to Santa Monica to try and get my money back, because I'm not going to do that, right? And we're not the only ones. Do we think most people know that? Or they don't care? Or who cares? They're too stupid to not read it. That's on them. Matt, what were you going to say?
I was just going to ask, organizations like AAA, they don't build up any kind of case law, do they? So
No.
that's an advantage for the businesses then.
It is a private body of law, AAA, American Arbitration Association. It's a private body of law that we're not aware, that we really don't get knowledge of.
They don't even follow precedent, do they? Not really.
Well, it's got rules, but there is no per se precedent, because it's not available.
There's really no chance that a favorable judge is going to upset things for them if they're just locked in.
No, and that's the problem, is we can't even always get a true history on the arbitrator. It's a private judicial system where, for instance, and that actually it's a good bridge to the next point. You've got an article about Judge Gertner in there. With real cases in real courts, we have the ability to access the earlier decisions, right? You know this. We also have the ability, and you to a much greater extent than I ever did in the early years of practicing, you can really track down every decision that judge ever made on not just trials, but on motions, you name it. There's a way to really get a complete body of work so you have a better understanding of what works with that judge and what doesn't. And if you don't do that, then that's shame on you. Because if you don't know how to pitch your case based on who it is you're pitching it to, and it makes a difference who's sitting up there, an incredible difference as to the value of your case and how you're going to present it. Because I get a judge that favors me, my number goes up. I get a judge that doesn't, my number goes down. And if you're not making that assessment throughout the case, but especially early on, then you're doing your client a disservice. And I wanted you to see Judge Gertner's information, because very atypical of a federal judge. You know, I remember when we had the ABA cases, the three judges in the federal court that were involved with our case, I think they were a total of like 230 years old. No, I'm not kidding. I'm not kidding. And they're all, white guys. I think that's a little excessive, but that's pretty typical of federal judges. There's not a lot of judges of color, and there's still not a lot of women, surprisingly. Even though, it's now been, 50 some odd years since women started to virtually be in the same numbers as men, mid-60s, say, maybe 70. So the fact is that you need to know your judge. And in the arbitration system, I can get information, and I share information with others, but I don't have that same body of work that I can look at and really get a much better feel. I've got to trust others' judgments of this or that arbitrator to a greater extent unless I have my own background with them. And that's another problem with arbitration, is it's a secret law that you don't have the same understanding of. Let's keep moving to this Harts versus Slits Brewing Company, which is, there's a required arbitration provision in here, and it goes to federal court because of diversity, and the court issues a preliminary mandatory injunction against the get termination of the distributorship pending arbitration between the parties. The brewer appeals. And the question really is, well, if we agree to arbitration, then who should have the authority to grant any form of injunctive relief, even pending the arbitration? And this is a legitimate issue, because if I can't even go to court to get an injunction pending the process we agreed to, then I'm going to lose my distributorship, and then I've got to sort of backtrack on the whole thing. If the agreement says that the arbitrator can issue some form of injunctive relief, well, that's great. But what if there's sort of this gap, or it's unstated? I mean, I would have done the same thing they did here. But what does it provide for? Because as it says at the top of 470, the principal issues are whether the agreement provides for maintenance of the status quo during the arbitration, and whether the availability of that relief is to be determined by the court or the arbitrator. Status quo we saw one time before, and what that's talking about, and this is favored in equity, is that it's the last undisturbed place the parties were before the matter came into contention. And so the court tends to favor maintenance of the status quo during the pendency of the lawsuit, because that's the last undisturbed place they were at, and if we leave them there until we resolve it, no one, at least theoretically, is hurt. But Schlitz says, whoa, wait a minute, you don't even have a right to go to court because of the arbitration provision, and so therefore the court really is without subject matter jurisdiction to entertain any claim. You've got to go to arbitration. And this is a legitimate argument that the parties will engage in if the issue is silent as to that. So when you're doing a business agreement and you have the opportunity to review the agreement with respect to that, you better make sure that there's a clear understanding as to what the rights would be to be able to get equitable relief pending arbitration, and who would it be that would have the ability to issue that. I would tend to favor the court having the ability, even during the pendency of the arbitration, simply because the court order is significantly more enforceable and more obtainable procedurally. We know how to get an injunction in federal court where you might empower the arbitration association to do it, but if they don't generally do it and you don't understand the process, it likely is going to be a mess to try and get one issued and to be able to get the process to begin. It's also going to cost you a lot more than the filing fee of a few $100s in federal court in order to start the arbitration process. Because nothing's going to get started until there's a lot more money than that on the table, because the arbitration, again, is a private body, is seeking compensation for their services. And it can run to an incredible amount of money depending on what the case is about. So the court is trying to figure out what it is they're supposed to do here, because if the arbitration provision removes the court's subject matter jurisdiction, then the court isn't authorized to be able to do it. But if they are, then what about providing the specific performance of the agreement until such time as we're able to sort this all out? All the court ultimately is able to do here as they sort through it is that while they will at the end of the day enforce the arbitration provision, because again federal law significantly favors it, since there is irreparable injury to Guinness, without the injunction it outweighs the hardship that may exist to Schlitz if an injunction is issued. And so at least pending the arbitration, they won't be able to terminate the agreement. But at the end of the day, that whether the agreement can be terminated or not is going to be decided by the arbitrator, not the courts. But the court has the power to issue the injunction. The next case in our sequence is Rosenberg versus Merrill Lynch. And again, this was Judge Gertner's case. And I think in this case, what they're trying to do is avoid the arbitration agreement, which at least the plaintiff feels likely favors the financial service company and is not favorable to her, where she would significantly prefer being able to go to court. But as you've seen, and this is why the case is interesting, and I think why they're very lucky to get Judge Gertner as opposed to someone else. And Judge Gertner, if you read the articles, has her past, not just by gender or age, is significantly different than most federal judges, but her background was really out of the mainstream for a federal judge. And so they're trying to get Judge Gertner to not go along with the arbitration provision, and I think her decision, and she goes out of her way to try and figure out under what terms, what facts, someone would have an ability to avoid what was clearly an agreement entered into by two sophisticated parties, such that they would have known what these provisions would entail. It's not, the Circuit City is one of the last cases in the sequence. I tell people that my son, when he was 16, went to get a job at Circuit City one summer and came back with an employee package that, about an inch and a half thick that he was supposed to have signed and returned to them the next day, waiving ridiculous amount of rights. But that's not the provision here. We've got sophisticated business people, but now that there's been a problem, and there's likely a waiver, the question is it an adequate waiver of her rights? And under what circumstances can it be determined to be knowingly and involuntarily made, well, she doesn't like what the effect is going to be. Why should she get out of it? I understand why she doesn't want to do it, but I don't think that, is there fraud, unequal bargaining power? There's almost always going to be some unequal bargaining power, but contract revocation, adhesion principles, unequal bargaining power, I mean, every employee, there's no equal bargaining power there, is there?
Doesn't she claim that she didn't sign the employee?
She didn't check the boxes
Yeah,
off.
that there was no such thing as the boxes checked, that she doesn't recollect of that she's claiming fraud.
Oh, she's saying she didn't check them,
Yeah.
someone else had to check them afterwards?
She never saw that.
So that's fraud.
Yeah,
So that's all she's going to say? Oh, I didn't check those boxes?
not really.
But that's your signature. You just didn't check the boxes. Well, so that's all I got to do? Because I can do that. No?
She has the burden to prove it.
She has the burden. So we should have had her initial. Is that what you recommend to your client next time? You have the business now? Don't check initial. No, right? How are you going to say, oh, that's on my initials?
Well, now you have to initial the boxes.
Huh?
Now they ask you to initial boxes.
So we're going to tell our client, if we want to make sure these onerous agreements are enforceable, have them initial, don't check. Well, why do we have to check anything? Why don't we just have them sign at the end? I agree to all the following stuff. And wouldn't that make more sense? Or I want to bold it and initial, because some of them do that too.
Slip a page in.
Huh?
You could slip an extra page in.
So I'm going to initial every page, sign the last.
No, you can do that, it just makes it easier, so later on there's no arguments, you know what I mean? It just makes it more.
So we'll initial every page, sign the last, and initial the really important provisions regarding waiver of rights. By the way, because this is an older case at this point, some of the federal statutes would in fact require now for, say, age discrimination claims or other specific claims, if there's going to be some waivers, then they may have to be in a certain type point face, which, by the way, I think that would be reasonable to recommend to your client that they're 12 point or bigger, something sufficiently
They're on a separate page now.
a separate page or bolded. So if you're going to do this type of work and advise companies, before some of the waivers of the rights, and some of the waivers of the rights then on termination, if you're dealing with the back end of this, where we're going to give you severance and we're going to terminate you, but we also want you to waive your age and civil rights claims and everything else, that there actually are provisions that some of those claims are not waivable within 60 days of termination or whatever it is, that you've got to sort of get them to re-up on day 61 or whatever. I forget the exact language right now, but if you're going to do it, there's got to be a period of time where you have an opportunity to think about it, even though you might well want them to waive those claims in advance. But there are going to be provisions that give the parties sort of a cooling off period and some chance to think. But if there's no statutory protection, either under state or federal law, then you're left with your own devices. And I think, as we see here, Judge Gertner is giving her a chance to prove that the process is rigged, a chance to prove that she shouldn't be bound by it, even though the law, to a significant extent, favors just that these days, which is that most claims are going to be subject to arbitration. But it universally, obviously, the person's got to sign it, right? And only the person who signed it is bound to the provision. So there's situations where the company president signs. Well, that doesn't mean the individual officers of the company are bound. Doesn't even necessarily mean that the company president as an individual, if he signs in a representative capacity, is bound. And so there is law that talks about that you do want to make sure, as this case is saying, is, well, did she agree to be bound by it? Was it knowingly and voluntarily entered into? And the first part of it is, if you didn't sign it, you can't be bound by it. And that's where the court oftentimes will look to as a starting point of reference. You have Thiessen versus General Electric Capital, right? And this was a class action under the Age Discrimination and Employment Act, alleging that he and other similarly situated employees had been discriminated against in age. Class action is filed under Rule 23. In order to proceed as a class action, you must show that a group too numerous for joinder have been injured as a result of common questions of law or fact. What we talk about then are the 5 whys, having to satisfy that in order to proceed as a class action. Commonality, typicality, adequacy or adequately, numerosity, and manageability. That if you can show those 5 things, then the case can proceed as a class action. If the case, as a class action, has numerous representatives spread beyond a single state, then the Class Action Fairness Act now allows that case to be entered into federal court or removed to federal court to a much greater extent. So, we've had a lot of class actions here on the wage and tip cases, the sky cap type cases, the I'm splitting my tips with management and they're not entitled to, or we're not getting overtime. A lot of those cases are going to be state-specific under various state laws, and they would stay here even though they're class actions. But a claim that has numerous parties from outside that single state, and I think the standard is it only needs to have more than 25% beyond a single state, that those actions can be and are quite easily removable to federal court. And again, the standard is still the 5 Ys, but there's a tendency to believe, which I think is accurate, is that the federal court will favor the right of the employer over the employee. This GE case, the class at one point was certified, but then the court, as is its right, can also go back and look at it again and ultimately decertifies the class, saying that, the court felt that there was less in common with respect to the plaintiff's claims on an individual basis than there were that allowed them to proceed collectively. If it's a patent or practice case, those cases are, and this is at least in part where the Walmart case fell apart. The court said that you can't necessarily say it's a patent or practice. You can't point us to a smoking gun piece of evidence that says women are going to get paid less at Walmart for the rest of their lives, because they should. What that case fell apart on is the manageability aspect of the Ys, saying, well, each plaintiff is going to have to show to a much greater extent that they were as qualified as the man who got the job or as qualified as the man doing the same job and therefore should have received the same pay. The problem with that is that requires such an individualized approach, as the language says here. Individual claims of discrimination, the focus has to be on the reason for the particular employment decisions at issue. That doesn't bode well for being able to proceed as a class action. It almost says that we're going to take all of these plaintiffs and look at each of their claims on an individual basis. The fact is that argues against moving forward on a class action basis, and therefore it makes it, to a much greater extent, let them proceed individually, and if they've got provisions in there that require them to arbitrate as opposed to going to EEOC or the MCAD, to agencies that would take discrimination-type claims, or, as Matt pointed out earlier, EEOC or MCAD could investigate claims on their own and then proceed to go forward. The fact is that it makes it much easier for plaintiffs to get some level of benefit as a class, even though they may be less, because they don't have to worry as much about resources, locating the attorney who will be able to help them pursue the claim, and then paying that attorney, and then there's strength in numbers. The fact is some of these claims brought by as class actions are significantly supported by what others under similar circumstances suffered the same fate. It's one thing to say Mike is less qualified than Jane, but when Mike is always less qualified than every Jane, and we've got a whole bunch of Mikes where the same thing has happened to 1,000,000 times, the fact is it's much harder for the defendant to be able to support the argument that there isn't some level of discriminatory animus involved here. And at the end of the day, if the plaintiffs can't show that, either individually or collectively, they're going to be out at any rate. The last one in this sequence I think you should have is Circuit City versus Adams, right? And again, 2001, and this is another one of these that when we looked at the employment agreements, and personally, as I start to think, and many companies have these provisions in here now, and the businesses want to do it for a few reasons. A, it resolves an issue far faster than anything else. B, I'm not faced with a jury Had this conversation with someone over the weekend who does employment cases, and think about it. Most people sitting on that jury are not the corporate hotshots. They're the people doing the work, who in many cases may hate their job or hate the corporate hotshots, but recognize that they've got to do this work, otherwise their bills aren't getting paid. And so businesses don't favor the jury system, both from the standpoint of the risk, businesses like to limit their risk, and B, out of the length of time it takes to have a jury potentially hear a case and resolve it. I mean, from a business standpoint, some businesses would rather get it over with quickly and take a big hit, figure out how to move on, than to have it drawn out for a couple of years, pay the lawyers an ungodly sum, and then still get hit with a big bill at the end. So the fact is that the companies favor it. But do we not, if you want a job, and many companies are now requiring you to sign away these waivers, that to me is more troubling about the earlier point. You don't have to buy something on eBay, right? You don't have to use PayPal. At some point, we all got to work. Are you worried at all about the unequal bargaining power, the unfairness of it, and waiving your rights to future claims and waiving your rights to a judicial process? Or, well, go work somewhere else or don't work at all. If you don't like it, you know going in, this is the deal.
A lot of jobs to choose from.
Not a lot of jobs to choose from.
Open up your own business, you don't have to sign anything.
Yeah, because we can just do that.
Yeah, you could go broke.
Right.
You still have liability towards others even though you have your own business.
Just saying there's not no options.
But to the extent that the practice is more widespread, and if you were representing an employer, I had a either a doctor or a dentist call me, and what he wanted to know is, can I put these in my patient agreements? Right? Waiver of court process, required arbitration, waiver of, well, why not? Waiver of 93A claims. Why not?
Why don't we just throw the whole Constitution away?
No, but you could go see another doctor. So why, go ahead.
That would make, that's like a public policy concern because.
Why?
Because every doctor would just have that type of agreement, so now if you want to be treated, you have to sign away all your rights.
Every employer would, every employer should, shouldn't they? Once I read a case that says, hey, you can do this. Why wouldn't you, you're representing the business, say, listen, you've got to have a forum selection clause. B, you better decide where it should be, whether it's court or arbitration, probably arbitration, you have more money than they do, and waiver of whatever claims we can waive to the extent that they're waivable. So the doctor can't have it, but your boss can? No, everyone can have it.
I was just asked to sign a waiver, waiving substantial rights to participate in this event for work, and I said no. So now they're like, well, we didn't expect anybody just to say no. But that's literally how it was written. So I'm waiving substantial right to what?
Right. So why? So other than your, well, this doesn't sound right, because you said what? Everyone would have it. But I think most employers have adopted this approach to the extent they can, those knowledgeable. And how many of us do say no? I remember my kids came home one time from middle school, that's a long time ago now, with this internet policy they had there, and they're in middle school. And I was supposed to sign off and indemnify them for any damages to their computer system that my children could cause to the North Andover schools. I took my pen and I crossed that out and I initialed it and sent it back. I don't know what damage those three could do, but I can tell you this. You let them use the computer, you better figure out how to protect yourselves, because that's your job. My job is at home here. Because I'm not signing off on that either.
If you had a contract where, I don't know, you had some kind of lease agreement or any kind of contract, and it was found to be like grossly unconscionable, in mass, would they just throw the whole thing out, or would they kind of just blue pencil.
I'm going to leave you with this last word, because I thought, and also, they played sports and different activities throughout the various times, and I thought that the waiver of liability was under mass public policy void. Until, for one of them I looked, because it said, even death, whatever happens to them, even death during a sporting, whatever activity they were going to engage in. And I said, well, that can't be, right? That's got to be void. And I looked, because mass law is pretty progressive. And when I looked it up, to my surprise, at least at the time, that type of waiver was not void under Massachusetts law if you knowing and voluntarily entered into it, which it would seem on public policy grounds that would encourage people to not be responsible in the activities they have people engage in, which would just seem to be ridiculously bad public policy. And I thought,
doing that.
huh?
Even doing that, because now let's say, I know, let's say if a tenants, and you just read a police and just put all this crazy stuff in there. I mean, you say, hey, well, just throw it on there and see what happens. The court, maybe they'll blue pencil this or that, but hey, maybe they'll take the rest of the junk. So it is weird that you'll just come up with the most, the most beneficial to yourself or your clients contract you can come up with, and just throw it out there.
Well, and the problem is that a lot of people, without your education, will look at it and say, oh, we're out of luck. Oh, we can't do this, we can't do that. Or they've got to come up with $500 to have a lawyer look at it to tell them they might have some rights. And it's going to probably be more than 4, because it's not just looking at the agreement. Now we've got to look at the statutes and see whether we're right or wrong. So the problem is that, and I agree with Jonathan that there are the concerns about access to the judicial process, because everyone will do them. The problem is the trend is that way. We've got federal courts who significantly favor them. We do have states, especially Mass, in some areas carving out, no, that's just not fair. No, we're not going to go that route. But we also have Mass cases that say, okay, this is the law. You did agree. You did know what you were doing. You're going to be bound. I'll see you next Tuesday.
Do I have to print that out? Can I send by email the questions?
Yeah, you can send it to me. Thank you. Who else? You go, Jim. Got you.